How is it that the concept, dare I say, cloak or slogan of human rights is being used to crush liberty? How is it that the invocation of human rights are stifling free speech, preventing individual citizens to debate, to disagree, to associate, to play sport? Women can't even go to the toilet safe in the knowledge there'll be no men there. During this discussion, we will answer the question, how did this happen? How is it that human rights became a weapon of oppression rather than an instrument of liberty? There are so many examples of how the invocation of rights is crushing the liberty of citizens to act in accordance with their worldviews and consciences. We're all familiar with the sports debates and toilets. So many birds have been killed with the human rights stone. The invalidation of citizenship with the Love case, where it was held that citizenship as a concept doesn't really exist. The Australian Law Reform Commission's use of anti-discrimination laws to attack religious freedom and effectively define what is and is not acceptable religious belief and associated practice. The finding of Federal Court Justice Mortimer's decision in Wooten versus Queensland, where police were declared to be systematically racist, despite no evidence that the police response to the riots in Palm Island had anything to do with race, and all necessary due process was followed. In the name of rights and equity, Indigenous people are treated differently by courts, ostensibly for positive discrimination. Now with Tickle versus Giggle, the insanity of trans ideology has been legally validated. All the foundational principles of diversity, inclusion, and equity have been validated by high courts who are not subject to democratic correction. The case Tickle versus Giggle does get media attention, but not the amount of press attention it deserves. And it's almost always framed by the mainstream media as positive vindication for progress, especially for trans rights. More and more people are hearing about this and starting to recognise the impact and importance of this case. I don't say this lightly, and I don't think it's hyperbole. This is the Mabo of human rights cases. And considering the international nature of human rights law, this Australian case will set a compelling precedent, definitely for Anglosphere countries and Western countries, but I suspect in the rest of the world. This is a big deal. Now, for those unaware of it, to give the briefest of backgrounds, Sal Grover, a magnificent millennial woman, returned to Australia after years in America after a successful career as a scriptwriter in Hollywood. She's smart, and I mean this only observationally for the purposes of context, beautiful, and consequently, she was subject to some real sexual abuse, genuine Me Too stuff from the predators in Hollywood. She returned home due to COVID visa changes, pretty scarred by her experience, as she told me in her interview. She started a female-only app, Giggle for Girls, designed to be an online female-only space to facilitate anything from finding accommodation through knitting circles, same-sex dating, whatever. A biological male who identifies as a woman named Roxy Tickle, no, seriously, joined the app, but once Cell saw Tickle's photo and recognised a biological male, Tickle was removed. Tickle made a complaint to the Federal Human Rights Commission. Cell refused to compromise, and the matter ended up in federal court. The case was named Giggle versus Tickle, rather than Grover versus Tickle, indicating someone at the court really does have a sense of humour. As a quick aside, Roxy Tickle isn't the only Australian who has a dissonance between their self-image and objective measurable reality. Recently, a biological female caused an international uproar when she identified and competed as a breakdancer at the Paris Olympics. But an Australian federal court recently ruled on self-definition, finding that legally speaking, a man can be a woman. But in his, and I hope I've used the judge's correct pronoun, writings, Justice Bromwich evaded the question of addressing the real issue, being, should the legal definition of woman have any link whatsoever with objective measurable reality? In his judgment, he specifically declined to answer that question. Now, I'm tempted to get all ironic here and make observations like, well, I suppose he's just a humble functionary interpreting the law, and the issue of the relationship between law and reality is too complex and above his pay grade. And after all, he is not a biologist. But I will say something unironically. It makes a very pleasant change not to have unelected judges interpreting words conveniently and thereby producing political policy. Like in the Love case, to pick an recent example, entirely at random. For what it's worth, he conveniently, one might argue, avoided the real issue. But I have to say, having read the entire judgment, I agree with his legal reasoning. For clarity, I'm not saying it's rational because he specifically avoided the question, should law be linked with reality? but his legal reasoning is sound and in line with the intentions of the legislation. That much is clear. Once you accept the axiom that this issue is not what is a woman, but is Tickle legally female, two different things, there is a high degree of internal consistency in the judge's judgment. But for me, reading this judgment answered the question, how is it that human rights legislation in institutions will be, in fact, must result in the crushing of civil liberties as we have conceived, known, and practiced up to this point at time? It's for a really simple reason. Human rights laws don't protect people, but immutable characteristics like race and assumed identities like gender. The Human Rights Commission does not see people as individual humans that happen to possess identity characteristics. It sees identity characteristics as possessing and therefore defining people. Because it's the identity characteristics that are protected by law, not the person, a regime founded on human rights believes it's both right and just if a person is severely punished to protect a characteristic. They see this as justice rather than its perversion. Common law systems are founded on a completely contrary conceptual framework. Instead, the axiomatic understanding of the common law system is that it's there to protect people and believes that characteristics, like a predisposition to steal, should be punished. Common law recognizes human characteristics, but does not assert that one or even a number of characteristics together define a person. For centuries since Magna Carta, there have been protection and rights woven into law and practice for every individual alleged to have been a criminal. But those protections and those practices are based on Western Judeo-Christian ideals of divine law, and consequently the practice of common law subordinates the characteristic, explicitly denying that traits, dispositions, and characteristics are what define a person. It's linked with religious ideas of what is authentically a human being and, of course, forgiveness. However, the human rights conceptualization holds the primary method of defining a person is not the humanity they share with all sons of Eve and daughters of Adam, but the traits and characteristics that possess that person. Now, this intellectual sleight of hand must result in a rearrangement of legal perception. Interpreting things through the lens of human rights divides us into tribes and creates a caste system of those tribes. Different characteristics have varying oppression ratings. There is an oppression hierarchy. There must be. Because the characteristic takes precedent and defines the person, it's a logical consequence that some people are more equal than others. Because of this foundational difference, the rights regime has a completely different definition of what a criminal is, what protections and rights mean, and limitations on who should be afforded protection and rights. Our traditional courts, with its precedents, relatively clear law, well-established interpretive principles, is adversarial, comparatively transparent, and treats people as individuals. In contrast, human rights laws are ambiguous. Interpretation is subjective, facilitating convenient application to approved collective identities. It refers to humans and people only as members of collectives. Yet both systems claim to administer justice. The House of Justice is divided against itself and in conflict. The human rights interpretive lens views Tickle versus Giggle, other cases mentioned relying on collectivist human rights principles like love, and two-tiered race-based justice administration as the very epitome of justness. Besides prohibiting certain behaviour, well-written, properly administrated laws limit when authority can act on individual citizens. The British common law system, with its high standards of proof, presumption of innocence, limits on what is admissible evidence, rights to silence, and adversarial rather than administrative nature stand in the way of woke activists. Now with Tickle versus Giggle, the insanity of trans ideology has been legally validated. All the foundational principles of diversity, inclusion, and equity have now been validated by the highest courts, who are not subject to democratic correction. Those judgments undermined the trust of the traditional courts in the minds of people like me who want to support common law systems. I've come to the unfortunate conclusion that it's necessary to believe what the woke say. It isn't just rhetoric when they label anyone who doesn't agree with them as Nazi reactionaries who are criminal threats. to social cohesion. They believe they are on the side of right, and this justifies all of their actions. Believe them when they say that they want to decolonize justice administration, which means discarding the foundational principles and assumptions of common law and replacing them with something new. The woke progressives are correct in their perception that British common law, with its accountability, transparency, checks and balances on state power, stands in the way. Removal of common law protections of citizens would enable the effective weaponisation of justice administration against the opponents of progressive ideology. In their minds, it's right and just that so-called trans-exclusionary radical feminists like Sal Grover or other reactionary deplorables are bullied through process, forced to be re-educated, lose their ability to participate in society, and eventually may even be locked up. It's no coincidence that it was a human rights issue that brought Dr. Jordan Peterson to frame. It was his refusal to use pronouns when mandated by human rights law Bill C-16 in Canada that launched him into world consciousness.
Bill C-16 purported to do nothing but extend human rights provisions to an excluded group, let's say, to the transgender and non-gender binary types, and that was the federal legislation. What's happened there is the government has introduced compelled speech legislation into the private sphere. It's never happened in the history of English common law. And so I said, there's no way I'm abiding by that. I don't care what your damn rationale is. We're compassionate. It's like, no, you're not. No, you're not. You're playing this radical collectivist left-wing game. You're trying to gain linguistic supremacy in the area of public discourse. You're doing that using compassion as a guise, and you're pulling the wool over people's eyes. And you're not going to do it with me.
If it wasn't for this human rights issue, there is no way that a comparatively unknown professor in Canada would have shot to international fame. There is something going on here. There is a reason why human rights regimes and international UN laws appeal so much to senior judges, especially those on federal and high courts. The appeal to high principles are above politics. They are informed by global values, enacting United Nations declarations which transcends the nation state or the Commonwealth. It's no coincidence that unelected, unaccountable judges want to cede yet more authority and power to global institutions. That way, the laws and institutions are safe from electoral cycles. Many of these laws and practices were introduced by stealth and practiced away from the public. Human rights tribunals are administrative and secretive. They work under cloaks of privacy, shielded from accountability and democratic correction. Sel herself made this observation.
There are some people who don't want to be or present as their sex. Okay, that's fine. Then there needs to be protections specifically for those people. But those protections cannot be at the expense of other people. Like, if this whole discussion had been that we want to have protections for trans women and trans men, okay.
Yeah.
Fine. But you can't even suggest that now without being accused of othering. And you're like, I'm not othering. I'm saying that I'm not othering in any way, like how saying that women need bathrooms separate from men are othering. You know, it's just, no, I'm saying that there's specific needs here. And let's recognize those specific needs. But instead of doing that in law, they just tried to punch it in and not go to any referendums, any plebiscites or anything like that. There's no mandates for these laws. That's the craziest thing. Yeah. Most people don't know that they've happened.
Yeah. I do recommend that interview, and there are some great short edits there as well. The Lioness Sal Grover, with the excellent Kath Deeds, her lawyer, have indicated the recent decision will be appealed. They hope the High Court will apply precedents, accepted methods of interpretation, and common understanding of the meanings of words like woman. But the High Court is full of ideological appointments who will impose a human rights regime. Those magnificent women are fighting in a completely new field of play. They're not the courts that we knew and owned. The interpretation of hazy, subjective principles has resulted in the courts becoming a chimera that changes shape depending on what legal method, reasoning, or principles are being used. Unfortunately, I suspect the High Court will find a way to do what it wants to do. It sounds counterinstinctive to say, but human rights are the greatest threat to individual liberty in Australia today. If that wasn't concerning enough, I'll end on this really concerning note. Those restructuring justice administration, without any democratic mandate, as Sel observed, need to ask themselves, how much focus can there be on racial identity before the white males who make up the majority of the working class, including the police, accept the proposition immutable characteristics like race are the values to shape society around. The good ones will just opt out. But I fear a time, especially with the loss of Christian value and turning of the other cheek, that many may conclude that they should just accept the hypothesis that race is all that matters and participate in the present affirmative action regime, changing only which race benefits. White men may be here on the hierarchy, but they still make up the tradespeople who build things, the muscle in the military, the people who know how to fight, and a caste-based justice system created by resentful people who have Western Christian values of tolerance and restraint and all the other protections in common law removed will look very different from the affirmative action utopia that exists only in the minds of human rights lawyers. The invocation of human rights is a powerful weapon because distortion of language and deceptive application of concepts makes it hard to identify, articulate, and therefore confront the threat. It took a man of Jordan Peterson's articulation and intelligence to do it. The halo effect of the invocation of human rights has protected human rights laws and the institutions enforcing them from serious scrutiny. All of us, me included, are in favour of people having liberty, but unfortunately it appears that people possessing liberty and human rights, at least as practiced, defined and categorised now, are mutually exclusive.